Good afternoon, Chip. Good to speak with you again, and thank you for co-hosting this session to discuss the challenges directors face when making cyber risk disclosure and how the FAIR framework can help them to make sense of these numbers. Now, to set the scene, I want to ask you to summarize the case where Joe Sullivan, former CISO at Uber, was recently charged with allegedly covering up a data breach at Uber that exposed information tied to roughly, I think, 57 million people.
Yeah, it was an interesting case because it really gets to the response of directors and senior lead companies, because what the case is against him is that he intentionally tried to cover up a breach as opposed to disclosing a breach by paying money to the hackers, calling it a bug bounty. I guess the government so far has decided that they're not buying that. But it is an interesting case to watch because it gets to how companies respond and disclose possible breaches.
Yeah, well, thanks for the summary. I completely agree with you. Now, I think it's very clear when someone's intentional withholding information in a criminal investigation is an indictable offense. But unfortunately, life is not always that simple, right? Because even unintentional failure in quantifying cyber risk in terms of potential loss, to inform the market of such a listed company could be equally be damaging. And the fact is, traditional approach in quantifying risk and expressing them in simply terms like high, medium, low, or red, yellow, green is no longer sufficient when fine-grained decision had to be made on the business decisions that might carry significant financial impact. Now, one of these cases you actually written about is the disclosure by Slack in the IPO in 2019. Can you share some insights with our delegates?
Yeah, one of the things that's interesting about the Slack case is it followed not too long after the SEC guidance in early 2018 on how companies are supposed to disclose. And so when Slack's IPO came out, their disclosure was, we've been hacked before, we're going to get hacked in the future, and we're not sure our insurance will cover it. That's a very broad statement. I think we're going to find out from our speakers today that there's going to have to be more specificity in the reporting of disclosing possible risk. And that really pushes you to a quantification approach.
Yeah, excellent. Yeah, well, thanks for the lead-in. On that note, I want to just invite our first guest, which is George, to share our insights as a director of a large NGO and how we manage this very challenge.
Hi. Look, thanks for inviting me today. I think it's really important, following on that discussion earlier about the criminal charges, to just stand back and assess the risks. So you've got reputational risk, you've now got regulatory risk, which could include criminal charges, but you've also got financial risk. And financial risk extends to the directors personally. In Australia, I argue that directors have a duty to prevent cybersecurity incidents, so they need to inquire with their general managers or CEOs what mechanisms are in place and make sure that there are measures in place, protect their customers' data, to disclose vulnerabilities, threats and incidents, and to investigate and remediate if an incident has taken place. So as a director myself, I'm extremely cognizant of the sensitive information that we have on our clients, and we take great care with it because the risks are enormous.
Yeah, well, that is really important as a duty as a director. Now, George, you are also a very successful class action lawyers, and you have won the first privacy-related class action in Australia. Tell us a little bit about how you might advise your client when they come to thinking about their responsibility and liability.
Yes, look, we were involved in the only privacy breach class action in Australia so far. And if I was advising a client, and remember, I usually look at this from the plaintiff's perspective, not the defendant's, I'd be making sure that my team took great care to protect customer information. I mean, we hear a lot about the breaches and the costs of the breaches, but I think what's more important is to actually take steps to ensure that the breach doesn't occur. Obviously, if the breach does occur, it must be disclosed and disclosed in full. If you attempt to hide information, that could lead to a regulatory breach, but it could also lead to litigation against a director personally.
Yeah. Go ahead, please, George.
No, that's it from.
Yeah, I was going to ask Chip, you know, I recall, and you wrote about the class action against former directors of Yahoo. Can you tell us, our audience, a little bit about that background? You are familiar with that.
That was an interesting case. I think that was one of really the first time that the directors were found, or that there was an agreement that the directors themselves were liable at some point. I believe the initial value, and I say initial because this thing is still working its way through a lot of different angles. I think the original is about a $29 million settlement, but I understand that has gone back, and there's, as with all cases, and George can talk about this anyway, is these things can go on forever, right? But the most important part was, the reason was that it was found that their actions directly affected the value of the company, right? Because the company is bought, by Verizon, and the value of the eventual sale dropped because of the breach notification. And I think that gets back to this quantitative risk situation. If you're making decisions that are going to affect the value of the company, whether that be because of breach, because of ransomware, right? The loss of operations, whatever those cases are, without understanding the value of, and the quantitative number of what the impact is, how do you make a good decision? And I think that's really what this session is about. How do I make those decisions at a director level, like on that types of activities?
That's exactly true. And George gave us an insight of those challenges in the Australian context, and Australia are very similar in many ways to the US. And this leads on to our second part of our session, is where we're going to look at the US situation, which is much more litigious. And on this note, I want to thank George for sharing time with us on introducing the topic, and I want to move on to our next guest to talk about the challenge of director liability in a class action context. Thank you, George.
Denny, yes, you're absolutely right that the environment that we have in the United States, where I live, is quite different than that of Australia. So let me introduce our second guest, Trish Carreiro. She is a cybersecurity and data privacy litigator who advises clients on the data breach prevention and response. She is certified information privacy professional, accredited by the International Association of Privacy Professionals, and experienced in high-stakes cybersecurity litigation. She's also handled many complex commercial litigation related to cybersecurity. Trish, welcome.
Thanks very much.
So recently, your firm published the class action survey, which compiled interviews with a number of general counsels across the country, and chief legal officers, and direct reports to those organizations. These interviews were really interesting in my view, because it showed the importance that companies are finding around litigation related to cybersecurity, related to privacy, and related to disclosure. Could you kind of give us a summary of that study and your findings, and what you kind of came out of that survey?
Sure. So we've been seeing consistent growth with how much the corporations we survey are spending on class actions generally, right? So last year, the companies we surveyed spent $2.64 billion in class action litigation, right? And 70% of respondents expect that growth to continue. And over 58% of them were particularly thinking that data privacy and cybersecurity class action litigation was going to be the next big wave in those class actions. And they are particularly concerned, 75% of them were particularly concerned with state statutes like the California Consumer Privacy Act. So one of them even referred to it as a walking lawsuit. And I think COVID has only made that wave larger, right? So starting this year up through May, the end of May of 2022, you had many class actions. By the end of May 2022, you already had over 560 class actions across the country. And those were COVID related and tended to focus on these jurisdictions that have more aggressive cybersecurity and privacy regulation. So California alone had over 100 of them by the end of May that were COVID related, right? But as far as the findings more generally, we're seeing a transition, right? So a few years ago, we saw this larger concern with data breaches specifically and the litigation that comes from those. Now companies seem increasingly concerned with whether they're going to trip over, in a sense, one of these state regulations that are popping up around the country. And this was the first year that every single company already had a formal data breach response plan in place. And I will say, remember, these are really large companies that we're talking about. So the same is certainly not true for all sizes of companies. But I think that shows a maturing in the field, right? Where you have cybersecurity and data breach response becoming more of an established, accepted part of business. And I think part of that is because companies are understanding that having these planned procedures in place saves them money, right? You have the Ponemon Institute study that found that companies who have these procedures in place and actually rehearse those, save an average of $1 million in post-breach costs, not insignificant.
Wow, Trish, that's a really great insight. And I'm so glad we in Australia, we call down under here, not quite at that same point. We probably can breathe just a little bit easier. For just a little bit longer, I'm sure things going to change in the same way like the US. Now, Josh told us a little bit about his responsibility as director in secure information and his success in the first privacy class action in Australia. In the US, on the other hand, as I understood it, that a number of very successful high-profile class action already, such as Equifax, right? And then also other really example of those such as what Chip have reported on with LabCorp recently. Now, can you tell us a little bit about what sort of lessons, Chip, that LabCorp should have learned from the lessons and how FAIR might be able to help them?
Yeah, well, and actually, Trish, I really like what you were talking about, the increase, which is, as you pointed out, there's the increase of activity around breach response. But how about just in general, when you look at some of the, you mentioned the LabCorp AMCA, for those on the call who are not familiar with that, AMCA was a subcontractor to LabCorp and got breached, and their response is basically claim bankruptcy and go away, right? So the question becomes, how did companies then start to kind of figure out how to monitor, how to quantify where their risks are and how to address that from a legal perspective, and also has enough information so that the decisions they make are justifiable, right? People are having to make cyber decisions. There's no guarantee they'll make the right ones, but that doesn't mean that they're liable. How do you address that issue, which is to say, hey, these are the decisions I made, why I made them, and if there's a class action, how could that be used in a response?
Right. So the way I'm understanding your question, correct me if I'm wrong, is does having this sort of fair approach, having these numbers to justify what you're doing help, and how does it help? Did I get that right?
You got it right.
All right, excellent. So I'd say there are two timeframes we're looking at, right? You have pre-breach and you have post-breach, and I think it helps for both. And I think those are related, of course. So pre-breach, having an idea of your exposure helps you to ensure that exposure appropriately. Second, it also lets you build a paper trail and basically create evidence for the future litigation, right? So you get to document why, with dollars and cents, what you did was reasonable. And that's important because I guarantee if there's a breach and a company is sued over it, the plaintiffs will say that whatever they did was unreasonable because they want to further their negligence claim, right? Because it'll survive a motion to dismiss. It's expensive to get rid of, and that's the goal here for the plaintiffs, right? So if you can point to evidence that shows, look, here is how we evaluated this with numbers that we had before the breach, which inherently seem more credible than anything we're going to come up with post-breach, with the plaintiffs will just say, well, you're just trying to explain your behavior after the fact. If we can point to that, then we've created a paper trail, we've created good evidence to use in the future, in addition to making sure that our decisions actually, from a more objective position, make sense and are reasonable. And that protects both the company and the directors and the officers who face increasing litigation over their cybersecurity decisions, right? And looking closely post-breach, knowing your exposure, having a sense of that, helps you with your class action strategy overall, right? So at the beginning of a class action litigation, there are two main considerations that legal decision makers often want to know when they're evaluating their strategy and how to go forward with that class action. One is the facts. Of course, we like when those are on our side, right? And the second part of it is the exposure. And so if you already have a sense of that exposure level, then you're a step ahead when considering, okay, how are we going to handle this class action?
Very good. Actually, I'm going to take one more question on this, on the state topic you mentioned.
Sure.
More and more, the guidance is not purely based on a breach response, right? If you look at New York DFS, CCPA, you could actually be fined even if you weren't breached, right? Which is because it's based on that you have taken appropriate, reasonable care activities. So again, back to this question, if I have a FAIR type or some type of quantified approach, does that help me address some of those state regulations that are out there?
Of course, because it's the same sort of showing of reasonableness that you have in place, right? Even where you have, these established frameworks for evaluating your risk, there's always that bit of, well, this has to be adjusted to your company and the circumstances and the threats you face. And by being able to point to, actual numbers, that's much more compelling with the regulators as well as with the court if you need it.
Right, very good. Well, I would tell you, as always, your insights are fantastic, and we could talk about this forever. Unfortunately, we're limited amount of time. Well, by the way, for those, I think this is a good topic to explore even deeper in future opportunities. I want to thank you. Again, your insights were great, and I appreciate what you've provided to us today.
Thank you.
Yeah, Trish, excellent. Thank you, really, for making time to speak with us and share your insights with our delegates. Thank you. Talk again. Well, Chip, it is really reassuring to hear from Trish that quantifying risk into numbers can really help to demonstrate reasonableness of the director's way of interpreting and disclosing cyber risk, as well as determining the cyber response processes. And this is in addition to adopting a good response framework. I want to pivot our conversation slightly by considering a common proxy for quantified cyber risk. which is cyber insurance. Now, cyber insurance occurs where the premium is calculated based on the estimated cyber risk exposure also through the underwriting process. Now, both of us has done a fair bit of research and writing about cyber insurance, and I found that from my research, the lack of historical claim data has been identified as a major constraint in the underwriting process. In fact, the Geneva Association, a global think tank for the insurance industry, published a research paper a couple of years ago in 2018, raising concern on what they call accumulation risk, which means the industry is a bit concerned of the uncertainty in the actual claim exposure to the industry through this uncertainty in the underwriting process. What's your thought?
Yes, Denny, you're right. And about this gap in the underwriting process, this is where Visesh, our third guest, can share his insight with us. Visesh, thank you for making time to speak with us this afternoon. You are a successful insurance professional and qualified actuary who is focused on risk management. A few years ago, you focused on building cyber modeling tools for insurers, and you're now chair of the Institute and Faculty of Actuaries Cyber Working Risk Party, and are on the advisory board of Cover, a cyber risk modeling firm. Given your experience, would you be able to explain to our audience how insurers are managing their portfolio risk, given the lack of historical claim data?
Yeah, I'd love to do that, and thank you so much for inviting me today. It's a pleasure to speak to the audience here. And before I get into that, it's probably worth just taking a moment to sort of say why it's relevant for the audience at a FAIR conference to hear more about what cyber insurers might be doing to get a handle on the cyber risk that organizations that those in the audience belong to pose to the insurer. So, you will be thinking about your own organizations and trying to make your cybersecurity much better. But we're in a new world now. We're in a world whereby you can take the appropriate measures to ensure your company is protected, but whether it be due to randomness, whether it be due to incompetence, whether it be due to something malicious internally, there are a number of reasons why, despite a significant amount of effort within your organization, you may still be breached. And so what insurance does is that provides both an indemnity in that case, but it also provides access to a range of services. And now that I've hopefully got the audience understanding why it's relevant to hear this, I'll move on, and I'll talk about sort of three different types of risk very briefly within a portfolio, and then I'll focus on the one that's the hardest to model, catastrophe risk. So there are three different ways of categorizing the risk that you're exposed to. The run-of-the-mill day-to-day is attritional, and these might be incidences with smaller companies that typically cost smaller amounts of money relative to an insurer's total portfolio, or it might be smaller incidents with larger companies, but again, they haven't cost an awful lot of money. Then you've got the same types of incidents, but as larger losses, and we consider those to be large losses. Typically with smaller organizations, you won't see them getting into the large loss bucket, but there may be some claims that do. Those are therefore rarer and a little bit harder to model. Catastrophe risk is quite hard to model. So that's where a single incident affects more than one organization. And so there have been a number of catastrophe events over the past few years, but not hundreds. So it's hard enough to model them given the small relative number compared to overall cyber incidents. What's even harder is the cyber world has changed significantly since the first of those catastrophe events, we can think about, back, a couple of decades ago, like the I Love You virus, which didn't cause a significant amount of disruption, but in today's world could have caused an awful lot of disruption had it been weaponized and had an appropriate payload. So when you're thinking about catastrophe risk, what you really need to do is understand what the organizations in your portfolio, what the characteristics are that they have that expose them to catastrophe risk, and expose your portfolio as a whole. So for example, your portfolio might contain lots of exposure to clients that use a particular Amazon service in a particular location, or other service providers where there's an aggregation. And similarly with technologies, I mean, everybody uses Windows, but there might be other technologies whereby only a smaller part of the market uses them, but you have an outsized exposure to that particular part of the portfolio. Now, that alone isn't enough information. What insurers can then start to overlay that with is think about the cyber hygiene within the companies and how that relates to companies that have been breached or had some form of disruption in the past. And then they can think about the cyber environment that's evolving and what today looks like versus what yesteryear looks like, and what the future might look like. And then there are some, with small amounts of data, you do have to make assumptions about how that extrapolates forward. Now, when we're thinking about catastrophes, it's really important to bear in mind that things come to the headlines that aren't always necessarily a big event. So, one example I'll give you that was a big event was NotPetya. NotPetya affected a huge amount of, a large amount of companies. And that was an attack through attack software that was trusted software that was rolled out, and by the bad actors getting into that trusted system, they were able to deliver malware to a large range of companies that trusted this software. And so this caused a large event, and then that was able to propagate through networks and infect a large number of companies. That was back in 2017. Last year, there was a set of headlines that came out about Dell PCs and how Dell PCs had a vulnerability that was incredibly bad, and if it was exploited, then it gave access to data, etc., etc. But what was missing until you read much deeper was the fact that that was not easily exploitable unless you were next to the PC. The difference between something that's a zero-click or a one-click exploit versus something that requires you to be present next to every PC you're exploiting, or do more with software that you're exploiting, means that if you have to do more, it's less viral. So the virality of that particular exploit doesn't have the same impact.
Yeah.
And the reason, sorry.
Go ahead.
Sorry. So the reason I say that is it's important to think when you're prioritizing risks of how easily those can spread, and that's what insurers think about as well when they're thinking about what they're exposed to.
That's great. Yeah, thank you, Visesh. That was insightful and a lot to really unpack. And I just want to quickly pick up one of the points you mentioned, where it will be helpful for the insurer to be able to factor in the cybersecurity hygiene into the underwriting process. And I want to draw attention to our audience that a new ISO standard, ISO 27102, was released at end of last year, October 2019, really to address that by helping insurers to standardize the language to leverage the information security management systems based on ISO 27001 to inform the underwriting process. And I want to really encourage audience to really learn more about that standard, and of course join the FAIR community to apply those awareness and knowledge. And on that note, I want to turn back over to Chip and to just say a few final words and close out our discussion.
Yeah, thank you. These are really interesting comments and really good insights on that. We've done FAIR assessments for companies looking at insurance, and some of the major points you brought out is where you actually get some of that feedback, right? Which is, what is the catastrophic? What is the medium? How do I measure that? How do I respond to that? What do I spend on that, right? You really get some good information on that. I really, I thought your input was really good. Do you have any final words kind of for our audience on this topic?
Yeah, actually, maybe a couple would be useful. Firstly, one on maybe a little bit more on how insurers think about portfolios and why it's sensible to insure. And then the second will just be about some of the services that insurers provide. And I'm not on a sales pitch for you to buy insurance. I think it is a decision that you have to make, and you have to decide that actually I'm prepared to take the risk because I think I've done everything I can, or maybe I recognize that there is something that could still go wrong despite my best efforts, and therefore I'd like insurance. But firstly, when the reason insurance is an effective mechanism, it's a pooling of risk. And what insurers try to do is insurers try to make sure that they're diversified in terms of their risk. And so therefore that harks back to what I was talking about before, about the fact that you'll have exposure when you're thinking about a portfolio to certain technologies, certain service providers. I'm on the advisory board of a cyber risk modeling firm, Cover, and they have a way of thinking about this called CRA zones, whereby they think about the type of industry, the size of the company, the geography, so that you can think as an insurer whether you are overall diversified or whether you've got aggregations of risk. And so that might explain sometimes why you get a very different price from one insurer to another, because you might actually be very beneficial in terms of that diversification because you're different to their portfolio in some way or form. And so don't be surprised that you might shop around and get a range of different prices from different insurers, but at the same time look at the coverages you're getting, because there are differences in the coverages that are provided by insurers, because cyber's a evolving product, and it can be hard to work out what limits you might wish to offer. And then the second point is, when if you make that decision to take out cyber insurance, once you've had a breach or some form of disruption, you have a phone to pick up, and most insureds do pick up the phone and get in touch and use the services that are provided. But there are some really valuable services provided pre-breach. So you can do an assessment externally. It's often heavily subsidized or free, so therefore minimal cost to you, reduces the chance of an event occurring because you've done that much more. And harking back to what Trish was saying in the prior interview, you're showing better that you've done the right sorts of things to actually protect yourself. You're showing more of the processes, and there's effectively an audit trail whereby you can display the correct thought processes. So it is really important that you do take advantage of those services, and uptake to date has been poor because people have a lot on their plates. But do take it, and if you have insurance already, then please do check whether you've been utilizing those services.
So thank you. Denny, I think we've had a great session here. We've talked everything about insurance, class action lawsuits, and how measurements and quantification apply to all of those. I appreciate the opportunity to participate in this, and you get to wrap it up.
Thank you very much. And yeah, once again, we thank you for making time to speak with us. And Chip, thank you for the opportunity to host this session. And I look forward to talking to both of you very soon. Thank you again. Bye for now.
Thank you very much.